Good morning, good afternoon. So I am very delighted to be here to discuss with you pivotal aspects in developments of the intellectual property landscape in Vietnam, especially in the field of industrial design. First and foremost, we will discuss Vietnam's accession to the Hague system and examine the implications and opportunities that this global framework brings for the protection of industrial designs. And following that, we will focus to the second key element, which are recent amendments in design regulation of Vietnam. So Vietnam has recently introduced significant changes to its design regulations. So we will explore these amendments and shedding light on their impacts they introduce to the existing legal framework. Lastly, we will focus on about the future, because we have some problems to solve, and we'll envision the trajectory that Vietnam's intellectual property landscape is set to traverse. Because technology, innovation, and global dynamics continue to shape the intellectual property landscape, so we have to consider the potential challenges, and opportunities that lie ahead. So now we will go to the first section. Is the accession of Vietnam to the Hague system. So, as you may know, industrial design is one of the fundamental subject to regulation by the law of intellectual property. Industrial design plays a role in bringing aesthetic value to a product, meeting customers' aesthetic preferences, thereby contributing to enhancing the competitiveness of the product. So, industrial design is increasingly becoming a valuable asset for businesses in Vietnam. So based on this, businesses are becoming more conscious of diversifying the patterns and styles of their products to attract customers, while also strengthening the registration of industrial designs to protect the valuable assets of their business. So, as you can see in the screen, statistical data show that the number of applications for industrial design in Vietnam has been increasing in recent years, including applications from both foreigners and Vietnamese identities. In recent times, Vietnam has witnessed a strong integration into the ASEAN community and the global economy and trade. Especially, Vietnam has signed 2 new generation free trade agreements. So the Comprehensive and Progressive Agreement for Trans-Pacific Partnerships, CPTPP, and the European Union Vietnam Free Trade Agreement, EVFTA. At the 43rd ASEAN Economic Minister meeting in August 2011 in Indonesia, ASEAN countries collectively agreed that on the ASEAN Intellectual Property Rights Action Plan for the period 2011 to 2016, one of the objectives outlined in this plan was to join the Hague Agreement to simplify the procedures for establishing rights for industrial designs for applicants in the region, thereby enhancing the competitive capabilities of the ASEAN economy globally. As you may know, both CPTPP and EVFTA contain provisions relating to the protection of industrial designs that Vietnam needs to consider amending its legal regulation to accommodate. Additionally, although not mandatory under the CPTPP, joining the Hague Agreement on international registration of industrial design is required under the EVFTA. So According to the EVFTA, each party signing the agreement must accede to the Hague Agreement under the Geneva Act 1999 within a period of 2 years from the effective date of the agreement. So on September 2019, on the sidelines of the 59th session of the WIPO General Assembly, the Minister of Science and Technology of Vietnam, on behalf of the government, submitted the instrument of accession to the Hague Agreement under the Geneva Act 1999. Accordingly, the agreement officially took effect in Vietnam from the December 30 in 2019. So Vietnam had previously joined the PCT agreement and the Madrid system. With the accession to the Hague Agreement, Vietnam has now become a full participant in all international agreements concerning the international registration of industrial property subjects. So as you may know, the benefits to the applicants when the Vietnam joined the Hague system. The Hague system allows the applicant to register their industrial designs with minimum procedures. The Hague system allows designation for protection in multiple countries with only one application. And the system also allows self-designation of the country of origin, and also allows the submission up to 100 industrial designs in the same application, and also permit the use of one of 3 languages, such as they are English, French, and Spanish. So designating multiple countries, so the applicants will have the protection in multiple countries with a single basic fee and a sole publication fee. So the fees will be reduced substantially for the industrial designs applications, especially for the second designs onward. So the applicants also doesn't need attorney fees or representation in each designated country. So you can see that with these benefits, Vietnamese applicants can reap the advantages of the system to gain the competitive. So joining the Hague Agreement holds a significant importance for Vietnam, as the ongoing trend of globalization, coupled with the increasing dynamism of international trade activities, has made the protection of industrial designs in many countries a crucial necessity for many businesses in Vietnam to safeguard their creative achievements relating to the appearance of the products in export markets. With Vietnam's accession to the Hague Agreement, owners of industrial designs in Vietnam can easily protect their designs in many member countries of the system, including major trading partners of Vietnam, such as China, Japan, the United States, the European Union, Singapore, and more. So this provides additional business opportunities in various potential markets. Also, joining the Hague Agreement contributes to the attracting foreign investment and encourages the export activity and for domestic enterprises. So with the Hague system, it helps promoting innovation by simplifying the entry process for domestic industries and owners of industrial designs into international markets. And also Vietnam's economy hopefully will reap the advantages of investments from foreign businesses that have protected industrial designs. So for IP Vietnam, we have the role as the office of the designated countries, also the role of the office of the applicant's contracting party. As the role of the contracting party of the applicants, we give advice to national applicants for many aspects. IP Vietnam educates national applicants about the benefits of the Hague system. This includes the ability to secure design protection in multiple countries through the centralized process, reducing complexity and potentially lowering costs for obtaining international registration protection. Also, IP Vietnam guides national applicants on the preparation and submission of the international application through the Hague system. This involves assisting the completion of necessary documents, ensuring that they comply with international requirements and facilitate the submission process. In the event of irregularity or refusal during the international application process, IP Vietnam advises national applicants and on the correct course of action, how to deal with the refusal, how to deal with the irregularities. IP Vietnam also assists the national applicants in managing their international design registration if they wish. This involves providing guidance on maintaining and updating registrations, addressing any changes to the project design, and ensuring ongoing compliance with the international standards. Also, IP Vietnam has a role as transmitter office in case of indirect filing of international application. Vietnam allows the Vietnamese applicants to use the indirect filing through IP Vietnam, and then IP Vietnam will send the application on behalf of the applicant to the IB of the WIPO. Vietnamese applicants are empowered to self-designate as the country of origin. Here is Vietnam for their industrial designs in the international application. So this flexibility allows them to choose the most strategic or advantageous way to file the national application. Instead of file the national application, they can file the international application and then self-designate Vietnam as the designated contracting party. So the ability to benefit from both indirect filing and self-designation will bring the reduction of potential costs for Vietnamese applicants. So the streamlined procedures and reduced administrative complexities also contribute to a more cost-effective approach to securing international registration and international protection for their industrial designs. And here you can see in the numbers. In recent years, the number of application designating Vietnam has steadily increased, as indicated in the graphs. This is not the number of designation for Vietnam each year based on the date of application, but rather than instead we will provide these numbers. They are the number of designations for Vietnam based on the publication date, meaning that the point at which international registration enters the national phase. Also, you can see in the this graph. This is the number of Hague designation counting for the design numbers. So you can see that this is not the number of designs designated in Vietnam each year based on the date of application, but based on the publication date. So you can see that is roughly two designs in one registration designating Vietnam. So next section, we will move to the amendments in design regulation in Vietnam. After joining the Hague Agreement, Vietnam has preserved several provisions of its national laws by making declarations in the instrument of accession. So these declarations assist Vietnam in meeting the necessary requirements for accession to the Hague Agreement, but at the same time pose certain challenges for applicants, leading to the loss of some advantages of the Hague system. Therefore, to effectively implement the Hague Agreement, the relevant legal provisions concerning industrial design protection need to be reviewed and amended to align with the agreement's requirements and be in harmony with the global trends in industrial design protection. And also in the context of economic development and globalization, intellectual property laws in Vietnam in general and industrial design protection laws, regulation in particular, are continually being refined. However, after nearly 20 years of implementing the first intellectual property law, the practical experience reveals that the current provisions of the law regarding industrial design still have certain shortcomings and issues that that they are no longer aligned with the international integration trends. So these deficiencies have a significant impact on the effectiveness of the RISE establishment authority, enforcement agency, causing difficulties for both industrial design applicants and the general public. So the industrial design protection system needs to be reviewed, to be amended to comprehensively address these issues. So based on the essential requirements for the economic development in Vietnam, the law amending and supplementing some articles of intellectual property law was enacted on June 16 of 2022 and has the effect from the 1st of January this year. The primary objective is this amended law is to provide strong strength for research, innovation, and ensure a comprehensive and effective legal framework for establishment, exploitation, and enforcement of industrial design, intellectual property rights. Two significant policies within the amended IP law directly pertaining to industrial design protection. The policies aims to facilitate the process of intellectual property rights establishment, aligning with the global trends in industrial design protection. Specifically, the first policy focused on creating favorable conditions for the process of establishing industrial property rights, including the industrial designs. And the second policy is to ensure the full and thorough implementation of Vietnam's international commitments on the intellectual property protection during the international integration processes. Also, the regulations regarding examination of Hague application are provided in the degree has been enforced since 23rd of the August this year. And also the revised guidelines on examination of industrial design applications is enacted from the May 2022. Now we are focused on the amendments in the IP law. One of the most significant new aspects of the amended IP law is the definition of the industrial designs. So according to the revised regulation, an industrial design is now defined as the outer appearance of a product or a part of a product capable of being assembled into a complex product, expressed in shape, size, dimensions, colors, or any combination and visible in the process of exploiting the use of a product or a complex product. In fact, the amended IP law does not provide a specific definition of what constitutes a complex product. However, this amendment aims to apply the provision of the EVFTA. On the amended law, introduced the concept of parts to be assembled into a complex product. This amendment does not change the scope of protected objects under the current legal framework. Instead, it aims to provide clarity regarding what qualifies as an industrial design. So according to the regulation under law, a product is defined as an object, tool, equipment, or part of the product which can assemble the whole product, manufactured by industrial or craft methods, having a clear structure and function, and circulating independently. So under the previous regulations, products with industrial designs encompass not only the whole products, but also the components and parts which can be circulated independently. So the new definition of industrial designs in itself confirms that Vietnam's industrial design protection system is for the whole article rather than for protecting only a part of a product which is not separable from the product. Although the new definition here does not explicitly mention the factor of independent circulation, the understanding of a complex product meaning as those products comprising multiple components that can be replaced, allowing for disassembly and reassembly of the product, and components of complex product as parts used for assembly into complex products. So this definition suggests that only components capable of independent circulation are within the scope of this definition. Another significant change in the amended intellectual property law is the simplification of the documents for design protection. Particularly here is the description and the claim. Here, the claim and the description are the components in the documents to obtain the registration under the previous law. An amended intellectual property law no longer requires the new law, the amended law no longer requires the description to include the part in which the applicant has to explain in detail the design features. Instead of that, the description in the amended law only required to list the essential appearance feature. So now the applicants don't have to create a detailed description, but only the list of the feature of the design along with the list of the drawings. And also, under the amended IP law, the claim is not required. In contrast, in the previous law, the claim is mandatory to secure the filing date. And also, in the amended intellectual property law, it allows design applicants to request the publication, to request for the deferment of the publication of their design application beyond the standard period of 2 months from the date of application is accepted as valid. But the deferment is not allowed to be exceeding 7 months from the filing date. Under the previous regulations, design applications were published within 2 months from the date of the application was accepted as valid. The last issue we'll focus here is the opposition mechanism. In the previous law, the third parties can make an opposition to the industrial design application before the decision of grant or refusal. However, in the amended IP law, the opposition only be requested before the decision of grant or refusal, but within 4 months from the publication date. Also, there's no opposition regarding the Hague application. This not regulated in the IP law, but provided in the decree guideline the IP law. Now we can move to the future outlook of the regulation relating to industrial design in Vietnam. Although the amendments have introduced in the IP law, new IP law, however, you can see that there's still some problems with the regulations, and they need to be reviewed and developed in the future. For example, firstly, at the moment, Vietnam is not participating in the WIPO digital asset service. Therefore, applicants must submit certified paper copies of priority documents. Especially for Hague applicants, they must submit paper documents directly into IP Vietnam. And you can see that more than 60% of Hague applications designating Vietnam has priority claim. So in order to interact with IP Vietnam, almost all application must to go through domestic IP attorneys, so diminishing the benefits of the Hague system. And I think that in the future, the solution is that Vietnam should participate in DAS system for the customer interest. Another problem is about the description. Also, the description is now not reduce the importance in the IP law after the amendments. A description will remain necessary to secure the filing date of a design application in Vietnam at the moment. Therefore, after joining the Hague, Vietnam made the declaration that the Hague applications designating Vietnam must include a description. However, within the Hague system, an additional fee of 2 francs is imposed for each word beyond the first 100 words for description exceeding the first 100 words. As a result, Hague applications like a comprehensive descriptions, all of them. So these applications have received provisional refusal notifications, and the applicants must appoint domestic attorney to respond. I think that this the solution for this problem is that Vietnam needs to review the IP law and maybe amend the IP law in the future so that the description should be optional, not mandatory. And another problem is about the protection of partial designs. At the moment, Vietnam does not provide for protection of partial designs, and in the future, Vietnam should consider providing protection for such designs because there are increasing requests and demands from the applicants to protect their partial designs in Vietnam. Secondly, at the moment, Vietnam does not provide protection for non-traditional designs. So items such as GUI, computer icons, virtual products in electronic games, and industrial designs relating to virtual reality or the metaverse are currently not addressed in the legal frameworks in Vietnam. These entities exist solely within the virtual environments, lacking the physical presence in the real world. However, due to the economic significance and it's easier to copy those objects. So with industrial design protection, these objects can be developed when there is emerging fields such as computing and AI or things like that. This sector holds significant development potential in Vietnam, particularly considering the younger population and a workforce passionate about technology. So the recognition for protection for non-traditional industrial designs is anticipated to not only drive the advancement of the telecommunications and technology sectors, but also help Vietnam's overall economic growth. So I think that to ensure Vietnam remains competitive in the technological development race, addressing various issues is crucial, and there is a pressing need to consider providing protection for non-traditional designs, especially in the presence of the fourth industrial revolution at the moment. Finish my presentation. If you have any question, please go ahead. Thank you for your attention.
Thank you very much for your presentation. So we have a couple of questions from the audience. Well, the first question is, in the amended design regulations, are there provisions dealing with the protection of designs for emerging types of designs in the digital world or the metaverse?
Thank you for the question. Unfortunately, at the moment, Vietnam regulation, Vietnam IP law and other regulations do not provide protection for non-traditional emerging technological objects. For example, UI or computer icons. Because in the definition and of the industrial design in the amended law, the object for protection remains the products or parts of product which is unable to be separated from the products. So you can imagine that the parts of product which can be circulated independently, only them can be protected under the industrial design regulation at the moment in Vietnam.
Okay, thank you very much for that. The second question is on the database of designs. Will Vietnam have any industrial design database in the near future other than WIPO Publish and the official Gazette? For example, an example is whether, well, the question is actually whether in the future Vietnam will have an image search for its designs available to the public using AI or an AI-powered image search.
Thank you for the question. At the moment, we don't have other database rather than the WIPO Publish and official Gazette. I think that in the near future, we don't have any plan for development new search tool for industrial designs or other industrial properties objects in Vietnam. We are Because at the moment we don't have experience in the AI for the searching tool, especially for industrial designs. For the internal database, for the internal search tools used for the trademark examiners, we are considering to develop AI-based search tool, but it's only in the first phase because we need to call for support from other offices and other countries and other call for the cooperation with the commercial enterprises in the world. I think that AI search tool is the vision for IP Vietnam in the near future, but only for the trademark examination and search. However, for industrial designs, at the moment there's no plan for AI-based search tool. I hope that in the near future we will achieve the support from UIPO or other offices and for such development. I really enjoy. I really think that we really need the AI-based classification for industrial designs because for classification of industrial design based on the local or domestic classification, now we need to do it manually, so it takes a long time. It takes a lot of time for us to classify design application into categories, into classification of local system.
Okay. Thank you. So maybe there's a follow up on that. Any plans for Vietnam to participate in Design View, because Design View has, if I'm not mistaken, image search. And also the UIPO also has design class, and certain offices integrate in Design View and design class. Is it something that the office may wish to consider?
At the moment, we are considering the integration the database of Vietnam into the design ASEAN Design View. However, it only relates to the exchange the data, and I think that it's not for us to it's not the plan for us to use the Design View or ASEAN Design View as a main tool for design search. At the moment, we use other search tools when we are searching the database in the world for examination of industrial designs. Also, Design View and ASEAN Design View are among them the design tools we use for search and examination, but it's not the only ones, because you know that every free search tool has drawbacks. So if we relied only on one tool, so it's not enough for us to conduct examination and conduct the prior art search.
Thank you very much. There's one final question on the average. What is the average processing time for a design to be registered in Vietnam? Because in certain ASEAN countries, there is an available express track where the design, where the process might be completed within 7 days. Is it something that Vietnam is also considering?
Can you explain? Can you repeat the question?
Okay, so what is the average right now? What is the average processing time to get a design registered in Vietnam? Is there a plan for Vietnam to reduce the processing time for the design registration? Because the question, the participant who asked the question mentioned an express track that is available in some ASEAN countries, and that it can take 7 days to have a design registered. Is there a plan for Vietnam to improve
You
or
mean
to reduce the number of the average time within which to register your design?
you mean that the average time from the filing date to the registration date?
Yes. Yes.
Yeah. Because Vietnam, in Vietnam, we conduct substantive examination, not only the formality checks. So the time for registration will be longer than some other countries. For example, for substantive examination, it takes about 7 months from the publication date, and in total, it takes around 10 months from the filing date to for the design to be registered. If the application has not any drawbacks, has not any irregularities, I think in the future we will consider to reducing time for examination, especially when we have when we have the opportunities to apply technological tools such as AI or things like that in the conduct of examination or in the classification. However, at the moment we don't have the plan to reduce the time for examination regulated in the law, because the 7 months are maybe suitable for us to conduct the substantive examination. Thank you.